Can't tell by phone. Yeah. No, I think that. Good evening, everyone. My name is Virginia Harger. I'm chairperson of the Shelton Planning and Zoning Commission. Today is Wednesday, August 27th, and the special meeting of the commission being conducted in Shelton City Hall via Zoom is hereby called to order at 6:05 p.m. This meeting is also being carried live on YouTube. But everyone, please rise to the pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. I'll start off the roll call of the commission. Please verbally indicate when the name is called. Commissioner Perkins. Present. Commissioner Cristiano.
Here.
Commissioner Amato. Here. Commissioner Tiki.
Here.
And okay, so it's Commissioners Perkins, Cristiano, Amato, and Tiki. Alternate Commissioner Apple.
Here.
Attorney Vince Titoso, our Corporation Counsel. Ms. Castro, our Assistant P&Z Administrator. Here. Mr. Ganji, our Professional Engineer. Evan Gutierrez, our Recording Secretary.
Here.
And Stephanie Charbonneau, our Stenographer.
Present.
And myself. For the record, Commissioner Kelly and alternate Commissioner McGee are not available for this evening's meeting. Alternate Commissioner Apple, you being seated for Commissioner Kelly. So please verbally indicate that you understand.
I do.
Very good. Couple of points before continuing with this evening's agenda. Ms. Castro will act as the team meeting host, while commissioners will be able to make comments throughout the meeting. The chair that asks that you please identify yourself and wait to be recognized before speaking to make sure we are not all speaking over each other, and to assist our recording secretary, make sure that he is clear as to who is speaking. First item on the agenda is other business and 824 referral from the city for the sale of land along Bridgeport Avenue, as described in a memo from Kelly Lozano, Administrative Assistant for the city. And I'll recognize Attorney Titoso to review this referral.
I think the commission is aware that this property and topic of the previous meetings. Also a topic with regard to the property hasn't changed. City acquired it, city selling for oil needs to be seen this process forward and the only
Any commissioner have any questions for Attorney Titoso? Make a motion for favorable approval. Okay, 24.
Second.
So there's a motion to report favorably on the 24 referral from Commissioner Partis, seconded by Commissioner Cristiano. So on the motion to approve, do a roll call. Commissioner Amato. Aye. Commissioner Tiki.
Aye.
Commissioner Cristiano.
Aye.
Commissioner Apple.
Aye.
Commissioner Parkins. Aye. And Chair votes aye. Motion to report favorably on the 824 referral has passed by a vote of 6-0. Next agenda item is revisiting the approval for an ADU at 395 Shelton Avenue. The person who appeared before us at our August 13th meeting indicated on two documents, page 5 of the application for a building permit, and on the bottom of the affidavit of ownership, She was the owner of the property when in fact, according to the assessor's card, LLC is the property owner. And it wasn't until August 22nd that upon request by staff that a document is filed by the LLC's agent member authorizing the person who appeared before us and who has indicated on those two documents I mentioned, that person who appeared was authorized to act on that entity's behalf. Does any commissioner wish to comment? Okay, so how does the commission wish to proceed with this agenda item? We have to,
Commissioner Cristiano, make the motion.
and that motion is,
Make motion to deny the application to rescind the approval that we had last time and deny the application without prejudice.
okay.
Second.
All right, so there's a motion to rescind the approval that was granted for the ADU, and the second part of that was denied without
Prejudice.
the,
Can I just comment or
yeah,
question?
let me just
Yeah.
finish this. We've got the motion on the table, so it's a two-part, rescind the approval and deny without prejudice. From Commissioner Cristiano, and it's Commissioner Apple, you second it, okay, so, Commissioner, Otto,
Yeah, the issue here is the question of ownership. Is that what we're saying? It's not clear.
it's clear on the assessor's card
Yeah.
who the owner is, but in two places on the documents that were, yeah.
Yeah, and it's not clear who's
And
living
it
there.
wasn't until after the fact that we received the document saying that person was authorized. So being denied without prejudice, the second part of this motion does permit the person to come back. So on a roll call vote, there's no further questions. Commissioner Parkins?
Aye.
Commissioner Apple?
Aye.
Commissioner Cristiano?
Aye.
Commissioner Tiki?
Aye.
Okay, Commissioner Amato?
Aye.
Chair votes aye, motion is passed by a vote 6-0. Does any commissioner wish to offer a motion regarding a waiver of the application fees if the property owner, the LLC, does wish to file a new, correct, and appropriate application?
The application is not paid yet. They're based on sales.
Okay, oh, all right, so we don't have to do any of that. All right. All right, so, we'll skip over that and then, so staff can work with the applicant, they so choose to continue with that. Okay, now, so next on the agenda, we have 3 public hearings, and I'd like to show the protocol that we always follow. Ms. Castro will indicate if any written comments were received from members of the public no later than 24 hours before the start of this evening's meeting. If written comments were received, they will be read into the record. The applicant and/or associates will make their presentation. The commission can ask questions during the presentation or at the conclusion. The applicant and/or associates can answer commission questions at the time they are presented or at the conclusion of the presentation. At the point in each public hearing, when the chair asks for public comments, we will begin with elected officials of the city present in the auditorium, followed by elected officials participating via Zoom or through a phone link. After elected officials conclude their comments, members of the public will be recognized, starting with those present in the auditorium, followed by those participating remotely via Zoom or through a phone link. Those in the auditorium will need to list their name on a speaker sheet up here at the conference table. Those participating via Zoom will need to use Zoom's raise your hand feature, and those participating via phone will need to dial *9 to be recognized, to be identified. After you are recognized, please state and spell your name and state your address to assist the recording secretary and stenographer when doing the minutes and transcript of public hearing. Each speaker has 5 minutes to present comments, which should address specific criteria of the zoning regulations, merits of the application, and be new information, not a repeat of comments presented by a previous speaker. Comments and questions should be directed to the commission, not to the applicant and/or associates. Members of the public are expected to practice appropriate etiquette by being quiet, observant, and respectful. Striking attendees may be removed from verbally participating. The applicant's attorney and their associates will be given the opportunity to address any comments or questions from the public after the last person from the public has been given the opportunity to speak. If the commission feels further information is needed from the applicant, the chair will ask for a motion to continue the public hearing. Public hearing remains open. The commission is not allowed to make any public comment, discuss any part of the applicant and or associate's presentation, or receive any additional information from anyone. And if the commission feels the applicant and or associates have answered all questions and have addressed all concerns from the commission and the public hearing will close. The commission reserves the right to discuss the application and close the public hearing, or to schedule a discussion at an upcoming commission meeting. In the time, the commission will be asked by the chair on how it wants to proceed. So this is the opening of the public hearing for application 2517, Robert Galito for TJ Donahue for a text amendment to schedule a permitted uses line 6C, allowing non-residential child care facilities within the LIP district via a special exception application. Commissioner Romano, would you read the notice of the public hearing?
Read exactly what you said.
Yeah.
Okay. Initiation of application 25-17, Robert Galito for TJ Donahue for a text amendment to schedule A permitted uses line 6C, requesting the allowance of non-residential child care facilities within the LIP district via a special exception application.
Okay. The application was accepted for review on August 13th. Posted on the city's website is the application for text amendment to zoning regulations. Ms. Castro, any other reports, materials, or correspondence received within the time period for this application but not yet posted to the city's website that need to be acknowledged for the record? No. Okay, and I see that the applicant is present. Attorney Guido?
That's correct, yes.
Okay, let's go ahead and see up here.
Okay, great. Do I need to turn this on?
Yeah, button up, you're good.
Okay, buttons up, it's good, okay.
All right, so identify yourself for the record, please.
Certainly,
I am the applicant. Should I sign it?
Well, you don't sign there, but yes, if you are. Mr. TJ.
right,
Sure, I haven't seen here somewhere. But, Attorney Polito's in this one off.
yes, that's correct.
Let me fix that shape.
It's right in your eyes. Oh.
So I agree, my husband.
More, somebody with height.
Oh, good on, Mark. Yeah.
Okay, all right. So as distracted as I am, go ahead.
Thank you very much.
Okay.
Good evening, members of the commission and all present. My name is Rob Polito Jr. I'm an attorney with Willinger and Busey. We have our office at 1000 Bridgeport Avenue here in Shelton at Suite 501, and I'm here on behalf of the applicant TJ Donahue. What we have before you is a text amendment request to change Schedule A permitted uses line number 6C to allow non-residential child care facilities within the LIP district via a special exception application. Currently in the zoning regs and the Schedule A, it is marked with an X, which means it's not permitted at all. What we are seeking to do is change that to an E, so a special exception will be allowed. Now, child care is an acute need in Shelton and pretty much every place in Fairfield County. Being a parent and grandparent myself, and any of you kids and grandkids know, it is very difficult to get into preschool programs, into daycare programs. The lists get very short very quickly. And here in an LIP district, it is a ideal location for this type of facility. They are typically surrounded by residential neighborhoods. There are businesses that are present within the LIP, employees who have children who would make good use of having a preschool facility and a child care facility within the area. Shelton is a growing town. I don't need to tell any of you that. There are people moving in constantly. There are new housing developments and townhouses, apartments, condominiums, etc. And there are many new businesses opening up in town. People with children need some place for those children to go so they can go work. while there are good child care facilities here in town, the fact is we're going to be needing more of them. And this is an ideal location. So what we're asking is that the special exception process be allowed so that a child care facility could go into an LIP district.
Is referring to all this, we don't have a specific location in mind.
We are-
As the application, you have something
Yes, we do.
down the line.
That's
We are under discussions for property on South Constitution Boulevard,
Okay.
75.
And just identify yourself for like
Excuse me.
before.
TJ Donahue.
Mhm.
I'm an attorney in Hartford, Connecticut, and I'm a member of the management team of the best school.
Okay.
So would this allow the transformation of a LIP facility into a daycare, and would it change the labeling of such buildings to something other than LIP? So would we be giving up an LIP?
No, because we're not looking to do a PDD, for example. So what we're looking to do is to be able to transform a particular building or, in some cases, maybe construct a new building within an LIP. So it would have a permitted use with special exception in an LIP district. So we're not looking to change the district per se, just the ability to
Not looking to
construct.
change this up.
That's correct.
Sure, Commissioner Apple?
Are you looking to have this as an accessory use within an existing building or just a freestanding operation?
So in this particular case, it would be a existing building that would be converted from its currently vacant, or is it?
It's a basic building at 175 South Constitution. It was a data center by a successful entrepreneur who's moved his data center business to Texas.
More power and cheaper.
And so this would be adapted to that.
But it's a single use for a single building, single use for a single building. Okay.
And it would occupy the whole entire building?
It would actually, we would have some return, but we'll have no subtenants or tenants. We are, I want the commission to help. We're very deeply in discussions with the owners of the building that we expect to get subject to zoning. We expect to move over. We're very anxious to get shown.
Yeah, what's the square footage of that building?
17, our patients.
Just want to leave this.
Yeah.
It has 13,904 square feet of office space.
Mhm.
And it has warehouse space of 6,000 square feet.
Almost a 10,000 square foot building.
No, 19. 13, 394.
19,000.
Yeah, 19.
So
What they're proposing is that the applications would have to come in front of the commission and a
Anyways.
special exception.
Right, and we can get into the details of that.
As we look through the town, there are several locations pre-existing throughout LIP zones. Some, specifically, there's one on 10 Progress Drive, 216 Longmore Crossroads. So they continue that use because they were pre-existing. Putting it this way allows the commission to have more control over how big or what part of the building you want to use certain area. So it would come through as a special exception.
Is this similar to what we did with the fitness operation? Wasn't that
Yes,
LIP?
they were, IA industrial, but they would have to come in, that one was a site plan application, but ultimately we would have to come back before the commission.
But it was a change of use in that. Because of unused, underutilized.
Correct.
Space.
Because it wasn't.
So you're not taking away from the industrial use, but allowing a vacant building to be used for other options.
Yeah. Well, in that case, that's what it was.
All right, anybody else have, any comments or questions before we, see who in the public wants to speak? Okay, is there one here for that application 2517?
It's just the attorney signature.
I might have signed in the wrong spot. Sorry.
That's all right.
No.
Okay, let me just throw out then, if there's any member of, any elected official here in the auditorium that want to speak on this application, please come up to. Wait, let me just toss out if there's any elected official participating via Zoom that would like to comment on this particular application, please use Zoom's raise your hand feature to dial *9.
No, I'm showing.
No, okay. And there is someone that has signed up. I'll ask one more time. Is there any member of the public here in the auditorium that can speak on this application? Please come up to the front. And if there's any member of the public who is participating remotely that would like to speak, use Zoom's raise your hand feature or dial *9 on your phone.
No, I'm showing.
No, okay. All right, so no comments for you to respond to. Is there any final comments, questions, or concerns from any members of the commission? Commissioner Tiki, you're participating remotely, or did you have anything that you wanted to comment on?
No, not at this time.
Very good. Okay, so, how would the commission like to, proceed on this particular?
Commissioner Cristiano, make the motion to close the public hearing.
Okay, so the motion to close public hearing from Commissioner Cristiano, is there a second?
I'll second.
Okay, Commissioner Morrow is seconded. On the motion to close public hearing, Commissioner Parkins? Aye. Commissioner Cristiano?
Aye.
Commissioner Morrow?
Aye.
Commissioner Tiki?
I
Commissioner Apple?
Aye.
Commissioner votes aye, motion to close is passed by a vote of 6-0. And how would the commission like to proceed on this particular application?
Madam Chair, I'd like to move forward tonight.
Okay, you have a motion?
Make a motion to approve, application 2517.
There's a motion to approve application 2517 from Commissioner Cristiano. Is there a second?
Second.
Second from Commissioner Apple. So on the motion to approve, Commissioner Perkins? Aye. Commissioner Apple?
Aye.
Commissioner Cristiano?
Aye.
Commissioner Amato?
Aye.
Commissioner Tiki?
I
And the chair votes aye, motion is passed by a vote of 6-0. Okay, we're set. Good luck.
Thank you very much. Appreciate your time tonight.
Very happy to go.
Oh, can we have an effective date?
Don't you have a date to recommend?
Yeah. September 5th.
All right, Commissioner Cristiano made the motion. Well, modify that for a effective date of September 10th, you said?
Fifth. Modify my motion for approval 2517, effective date of September 5th, 2025.
Okay, Commissioner Hopper, you seconded it?
I do.
Okay, so when you do a roll call, Commissioner Perkins on modification, okay, Commissioner Hopper.
Aye.
Commissioner Amato.
Aye.
Commissioner Tiki.
I
Commissioner Cristiano.
Aye.
Two votes aye, motion is passed by vote 0. This application, approval is supposed to take effect on September 5th. Okay, next is the public hearing for application 2513. Dominic Thomas for Catherine Benedito for a text amendment, shelter planning and zoning regulations, sections 24.11, 24.11.1, 24.11.2, and 24.11.4 to permit typical same square footage of the underlying zone, less the square footage of the access way. And Commissioner Martin, would you read the legal notice?
Initiation of application 25-13, Dominic Thomas for Catherine Benedito for a text amendment to shelter planning and zoning regulations, sections 24.11, 24.11.1, 24.11.2, and 24.11.4 to permit interior lots of the same square footage as the underlying zone, less the square footage of the access way.
Okay, thank you. Here now, Judy, sometimes you said.
Yep, we approve it. Thank you.
Right, I'm gonna send up the, commission scan and recess for minutes.
I am finally, I believe. Set up. I am set.
All right, so we're gonna reconvene at 6:34. And, Scudeers, you need to make sure that you. No. All right, so, this application was accepted for review on August 13th. Posted on the city's website is the application for a text amendment, a copy of the opinion of the court in 1998 in the case of PHC Company versus Shelton Planning and Zoning Commission, and a referral report to the Naugatuck Valley Council of Governments. Ms. Castro, any other reports, materials, or correspondence received within the time period of the application for tonight, posted to the city's website? I need to be acknowledged. No. Okay. So, Attorney Thomas, please identify yourself for the record and proceed.
Attorney Dominic Thomas, Cohen and Thomas, the Main Street, Derby, Connecticut, representing the applicant, Captain Benito, who is present in the audience this evening. My client came to me with a request that on the property that her parents own, that she be able to get an interior lot. And it's her intention to build there when she gets married. And I had to inform her that despite the fact that the lot provided sufficient space for her to have a zoning compliant 40,000 square foot lot without counting the access way. I said the requirement was an acre and a half. I did have some discussions in the hope that this commission, I brought it up, but there was a lot of issues going back and forth, and I was hoping it would be something related to both housing and correcting something that, in my opinion, needed to be addressed. I am not a planner. I do attend a lot of planning functions, and the idea of an interior lot being 1.5 times, or in some towns, 2 times the size of the basic underlying zone has no planning function whatsoever. And it is just something that was put into a lot of zone. What is interesting about Shelton, and I took the opportunity, and I know I must have, when I did this, John Welsh was sitting on my shoulder. Back in 1998, the issue, not with me representing the Bridgeport Hydraulic Company, but their lawyers sued the city and appealed the city when a interior lot was turned down somewhere off Huntington Center on the grounds that in your regulation, at the very beginning of your regulation in 2411, it said that if the commission determines that interior lots, it has to determine if it's in the best interest of the city of Shelton. And the case went to Superior Court. Judge Ripley rendered a decision saying that it's an illegal provision, because if the lot complies with all the requirements, it is an appropriate lot, and it needs to be. So I just wanted to explain that's why that portion was crossed out. It would just apply with this case, which I uploaded to your website.
What standing would Bridgeport Hydraulic have?
They were developing property.
Oh.
They were developing, they did subdivisions back then, and themselves. And this was my understanding, I wasn't involved. My understanding, this was a parcel somewhere off of Huntington Street, off the center. 1998. And it was Judge Ripley who, I think this was the only case Judge Ripley ever ruled in favor of the applicant as opposed to the city. But that, I just wanted to explain, that's why that is in there, because this has been around for a while. I did upload the case. So the other thing I did is that in many of the areas, the access ways are 25 feet, which are plenty enough to put your driveway in. That's something the commission can certainly consider. And I removed, obviously, the 1.5 times. What I passed out to you, just so you know, and what was added in green there was the result of a request I received to determine how many parcels in the city this would, how many parcels in the city this would impact. Well, first of all, in the city, under your regulations, it impacts R1A, which is a very large zone of 120,000 square feet per line. R1, which is your 40,000 square foot. R2 and R3. I will tell you, and let me see if I can screen share here with it. I will tell you, and I did this, I split up, by the way, I split up your zone map into two things. I contacted NBCOG, and what they told me is, you know, I gave them my chart, the green chart, and here's how I developed the little green chart. I took, obviously, the R1A zone to be 1.5 times the size, the interior lot would have to be 180,000 square feet. So I just added the two together. And in each case, I added 5,000, a completely arbitrary number that would be a 25 foot by whatever, access way, because you don't count access way.
Did you guys follow something? The green?
And added to that, in the last page, which is significant, is your 5.27. So in fact, I just want to tell you, it would be virtually impossible to identify. You can identify parcels that it would apply to simply because they exceed or they match the number of square feet. But that being said, that's just the first step. Then they'd have to comply with 5.27 with the slopes and everything else that goes with that. Do they have sewer? Do they have water? There's all these other things that go into it. The whole point is that there is no real planning benefit to it. In many of the cases, in the NBCOG said it could take them 2 to 3 days. They might be able to identify the parcels by size, you know, by incorporating it in. I mean, if you want to take the time, as I did, to put it on the computer and blow it up, like for instance, to the R2, like for instance, R2 zones, you can look in here. What is it? This doesn't. Okay, here we go. And the R2 zones. Oh boy, that's good. Now let me try.
It's gonna be real slow.
There's something. It was a little iffy. Tony, if I just want to see if I can get the. It is cutting. The internet is cutting in and out with mine. Let me see if I can get over there. This is shop the internet access there. Okay, we get it back. We got it back. Okay. So, for example, what I was trying to do, and hopefully it will work this time. If you look at your R2 in the Huntington Center area, okay, you can eyeball there. And if you go to the GIS and click on some of the larger parcels, there's City of Shelton. There's really no parcels within the R2 zone there. And there are other R2 areas that, yes, there may be a parcel or two that would fit in the R2 zone, the requirement of having 45,000 square feet. But what is it you're increasing? You're increasing the possibility of single family homes. These are not anything else. These are all single family zones. So the R1A, R1, R2, and R3 zones, they're just single family zones. And when you're talking about interior lots, that's what it applies to. It doesn't apply to anything else. So the opportunity in my client's case, on the property that her family lives on, the engineer that was involved, I asked him, so we're not wasting anybody's time, to please lay out, to make sure that 40,000 square foot fit, make sure there were no slopes or anything that would impact it, and make sure it has the thing, and it would. She would have to come back before you based on the length of this time with a re-subdivision application, which would require a public hearing. And except for those people that claim a free split, anyway, everybody else would have to come before you in it, in large parcels. The other thing is, there are an abundance of larger parcels that people own that could be developed for subdivisions. I'm sure you realize you haven't had many single-family subdivisions. There've been a few, but not many single-family subdivisions. And what it would mean is that potentially you could have an extra lot or two in a single-family subdivision, because if there were, the way it was laid out, it required interior, it's a material lot, maybe it would get an extra one or two, depending on the size of the property. But from a planning perspective, the extra size doesn't, there isn't anything to say, well, and from a planning perspective, it's better to have, there's nothing that fills in. When you research it, when you look at I go on the APA, I signed up on their website, and I go on there and I do some research. And basically, there was one statement in there that said, no, there is generally no land use planning benefit to interior lots being larger than front lots. Now, they should obviously be compliant, and that compliance should not include the access way, which is a common thing. That's a very common thing. The other changes that I made are with respect to setbacks is basically, that was in 24.11.4, was basically that on any interior lot, they have to comply with all the setbacks that are in Schedule B. So they have to have the same setbacks.
On that 24.11.4, could you look at that second one that's it's in black? Any interior lot, any district, all buildings or other structures.
Shall comply with the setbacks in Schedule B, the last line.
Oh, there it is.
Yeah, shall comply. Gets a little freaky when you're changing the entire paragraph. So, that's the basically simple version of it. It's obviously for the benefit of my client, but obviously you've got to understand the impact.
The access way not being included in the lots that are on the main street, the driveways are part of the lot size, right? So where do you
They are, but
set off?
that's in your regulation.
Right.
That's already in your regulation. Where did that come from? I have no idea, but basically they didn't want to count it. I guess that is very common.
Well,
in
it's
other
long.
countries.
It's more square footage.
Yeah,
And would allow somebody to have a much smaller,
well,
if you counted that.
Yeah. Well, the interesting thing is the way I drafted that. I asked the engineer to make sure this was fits. I left in all the other provisions, and one of the provisions you have impacts these lots seriously. If you're interested in single family homes, in that you have 135 feet of frontage. So in my conversations with the surveyor and everything, you have enough frontage, which means you have to have that plus that. You really have to have more, because you have the 150-foot square, which was put in many years ago to ensure that you didn't have odd-shaped lots. So now that interior lot still has to have 50-foot square. So you couldn't, that's one of the reasons, you take it out, because then you're going to have this, some towns call it flag lots. Now, that's what they call it. But that lot where you have it, you have to comply with all of the requirements. You have to comply with all the setbacks. You have to comply with the 50-foot square, and the parcel has to be big enough. At a minimum, parcel has to be big enough. But the way I drafted this to be 135 and 25, never was it 160? 160 feet across. But even with that,
You're talking about
probably,
R1. You're talking about R1.
R1, I'm talking about R1. Even with that, you're probably gonna have to be longer on your frontage.
You don't get 150
Yeah, I mean, you do if the lot is something like this, you know, glaring out like that. But like Commissioner Apple said, you really don't get it. So it still has plenty of restrictions. Prevent action.
Attorney Thomas, so I understand, to summarize what you presented here tonight. You came here with that story about a lady who's engaged and wants to live behind her parents, and you're asking to restructure the entire city of Shelton.
It's basically the only way to do it. There's no other way.
Okay, so
For her to do it.
you want us to vote on you restructuring every neighborhood in Shelton. Okay,
I don't know. if-
with an you can't even calculate the number of properties that this would affect. The impact and water pollution control, adding what you're saying is you can't even calculate the number of properties.
No,
Okay,
no.
so long-term impact to our water pollution control system in Shelton can't even be calculated at this point, right, by your own statement.
Well, what I meant was that you have raw numbers. You have, say, you know, this is what the impact is. You can have, if you do the raw math, it's 85,500 square feet.
But you're unable to tell us the total number of lots that are impacted currently.
That could.
You don't know that there's 10 lots or 1,000 lots.
You could,
So we can't,
no,
from my point of view.
Yeah.
It'd be 20,000. If you don't have an idea of what the impact is, we're kind of, kissing a pig in the dark.
in my conversation, and this would be the responsibility, in my conversation with the individual guru in the car, who does, he can run those numbers. But those numbers would give you no information whatsoever as to whether or not
But
the properties that are identified.
it's still
Part of the equation.
Can I just say, we don't know how many rear lots could be created based on current information.
Yeah.
Anyway,
Yeah.
the point to me is, but I don't personally see any rationale behind that provision, that those lots be 1.5 times bigger. Yeah, I know, but if somebody could explain to me the rationale, I'm open to that, but I never have.
Yeah.
What?
He's no longer.
But if we were to reconsider that, right, as a commission, as a city, we would do the research to see how it would impact the city, right? It
Well,
would
that's
be based
a
on
good
one
point.
application.
That is a very valid
So
point.
anytime we write, and I don't really consider this a text amendment, I consider this a rewrite of the regs. And so anytime we do that, we do the research to make sure that what we're doing is sound practice.
Well, that makes sense. But I'm just saying, we don't know how many rear lots could be created at 1.5 times size. We don't. So
But again,
to me,
rear lots.
it's just a question of whether it makes sense to have rear lots be bigger, and I don't know what the rationale is.
Yes.
So
What I'm saying.
Attorney Thomas said that you left all the existing regs alone, but you really didn't, because in 2411.1, you're reducing the size of the frontage for the driveway from 30 to 25. What's the rationale behind that?
That was,
Because it fits this lot,
no. It's not.
so why did they reduce it?
Because 20 by 1 is the normal size in most of the other communities.
But it's been 30 in ours for 60 years.
And you're welcome to reject that and say, we'll keep it 30.
And in section 2411.2, you've got the sentence that includes the same statement twice. I'm trying to figure out what we're trying. It says the area of each interior lot exclusive of its access way shall not be less than the minimum lot area otherwise required by these regulations for the district in which is located, not including the access way area.
That was a draft, because it was in the first sentence.
But you offered it as a change. So it's inaccurate.
Yes, it doesn't need to be in there. The second one does it, just the 1.5 times needs to be crossed out. The second one does, and I wanted to make it clear that it did not include the access way, and I did that without realizing it's in the first sentence. But again,
And then you're reducing the setbacks in 2411.4 you're reducing all of the setbacks that currently exist to the setbacks that are for a regular lot.
Yes.
Why?
Because there would be, again, there's no valid reason for that. The setbacks under the R1, but
But
typically
this
the
commission
R1
has the right to set setbacks, and it did. So my question is, why would you reduce them?
because I do not believe they have any planning function whatsoever in the setbacks in the R1 zone. If the lot size is gonna remain the same, the lot size should, when in the interior lot should be governed by the same rules, the square, the setbacks. So that was to say that it governed by that.
But if they call it a rear lot, it doesn't necessarily mean that it's the back of a property tucked into the woods. Okay? These, you could put, you're proposing is you could put another house and it could be next to your neighbor. Okay, the positioning of a street could mean that this second house could be next to your neighbor's house. Okay?
With the appropriate setback.
Right, with the appropriate setback. So it's not just this, right, this idea of a rear lot doesn't mean it's deep in the woods, you're gonna clear cut woods and it's gonna be tucked in the back where no one's gonna see it. So you're proposing to restructure entire neighborhoods, the layout of entire neighborhoods to conform to.
All I will tell you on that is, and I've done this, but, again, I hope, I brought this up early on, and I hope that the commission will look at it, because it increases, potentially could increase the house, the stock of single family
Why not?
homes. Huh?
Why, how many?
Depends on what, but if you look at what I put up on the screen, and you look at the developed lots, you go, I don't have it up there, you switch to the GIS, and you pick out a street in an R1 zone, and go down the street, for example, you look at the R1 zone that is to the left of, the R2 zone in Huntington Center, and you run up with it, you probably wouldn't find more than one or two at most.
The attorney's house, that's the documentation, needs compiled.
It is,
As part of
okay.
your.
the point that I want to make is, it is virtually impossible. Once you get the map, you still got to find out if the lot would be possible. You know what I mean? So even though you have,
Attorney's house, that you're the applicant, would have compiled. it.
Well,
It's
I
not-
agree with
do the
Commissioner
research.
Parker, this is a rewrite, not just a text thing.
Mhm.
You're making so many changes to the existing regulations.
well,
You're gutting most of it.
with all due respect, the main change here is that it goes from 1.5 times to the amount of the zone. The other things are to make sense. I mean, the one in 2411 is to comply with the court case from 1998. That's been talked about change, and it's never been changed. Obviously, the frontage thing, the commission could look at it and say, we would rather keep it at 30. There's no issue there. And basically, 2411.4 says whatever exists in the setbacks, exists in the setback. So for example, in the R1 zone, your side setbacks, I believe, are 30, excuse me, your side setbacks are 30 feet. I believe in the R1 zone, so you're talking about, the side setback, could be, because if you take it at 40 feet and you're returning it to the 40,000 square feet, you may make the zone, you may make it unbuildable. If your setback is too large. Remember, the 40 feet is based on it being 1.5 times the side.
All right. Anything else you want to, is that,
No.
that's the public input. All right, if, but before you, any other further questions from the commission for 30 minutes? Okay, so, oh, go ahead. Mr. Kennedy.
Can I again, planning and zoning, is the intent to use the pole of the flag as a common driveway?
That would be part of any application. It's not the intent to use it as a common driveway, but certainly a person could come in and request that to reduce curb cuts, you have, but in certain circumstances, you may have the driveway on the other side of the park.
Because the concept isn't necessarily that there's a house in the front and somebody's gonna propose one in the back. Could be someone who's wanna do it with both,
Mhm.
and you could use the flag, the pole, as access to the driveway, to the garage of the first one, and to the one in the back.
And that's what I've done it.
You said Paul would be there already.
The flag piece, remember what happened?
The access
Looks
way,
like a-
whether
looks
the
like a
access
flag.
way.
Access way is right, it's a flag.
Pole-
That's why it's called a flag lot.
Yeah, many towns call it flag. And that's the pole of the flag and flag. Yeah, I mean, there is one other thing, I mean, that's been done in some other towns, and that is that, and could certainly be added to it, and that is that any interior lot, in some towns, have to be approved by special exception instead of, site plan. In some towns, that's been challenged, I don't recall how that it's come out, but it would have to be approved by special exception, so if there were some sort of a unique factor that were in it, then it would, it could be addressed by the commission under its discretion, under, the special exception.
Like something that would open yourself up to a lawsuit by the.
That possibility would exist, yeah.
All right, so, we're gonna move into the public portion. And if there's any elected officials here, in the auditorium that would like to comment on this proposal, please, come forward. If there's any elected officials participating via Zoom or using their phone, if you'd like to comment on this, please, use Zoom's raise your hand feature or dial *9. Identified. Okay, so the person that has signed up is Fred Balmer, 391 Shelton Avenue. Come on up. Sometimes you move that mic over there, please. So we're gonna state your name for the record.
My name is Fred Balmer. I live at 391 Shelton Avenue in Shelton. And I'll keep it brief. I believe the majority of the voters in the city of Shelton are unaware of the issues that are presented to this board. They rely on elected representatives to decide what is in the best interest of the city of Shelton. To delete this text and removing it is at the heart of this board's function. It is sad to see this phrase removed from the text, because that's what it's all about. It's whatever is in the best interest of the city of Shelton. And for a single applicant to decide the lot size and the setbacks to be changed for the entire city is not what is in the best interest of the city. It could be replaced by what is in the best interest of the developers. So these houses that are coming up that have interior lots are being snatched up by the developers in hopes they can cram a few more houses into their back lots. And it's going to change the character of Shelton as a whole. And you are the only ones that can prevent that from happening. Please deny this request for change of text. Thank you.
Okay, thank you, Mr. Balmer. Is there anyone else in the audience that wanted to speak but did not sign up? Okay, if there's anyone from the public who's participating via Zoom or through the phone link, please use Zoom's raise your hand feature to be identified with dial *9. Okay. Mr. Harbison, you want to identify yourself for the record and proceed?
Sure. Thank you. Thomas Harbinson, Shelton, Connecticut. Two items I just want to add. The document submitted with the application from Westlaw, with a lawsuit from the city versus BHC. A little reference, I believe that it was for a property on Mill Street where Bridgeport Hydraulic was looking to subdivide it into lots. And subsequent to them not achieving that, the city did buy that as open space. And that was part of the larger Bridgeport Hydraulic purchase accomplished in 1998. Secondly, and I'm reiterating things I've said in the past, this town needs a city planner, period. This application, through a little internet sleuthing, I assume is going to mostly impact 93 North Street, a 2.08 acre lot that has ownership with the same surname as the applicant. Looking in that neighborhood, there are several parcels right away which would be able to utilize this zone change. A town planner would review that and see if that is an aspect that the city wants to impose citywide within its regulations. Again, you need a city planner. Thank you very much.
Thank you, Mr. Harbison. Castro, anyone else from the public? No. Okay, Attorney Thomas, you want to respond to Mr. Ballmer or Mr. Harbison?
Mr. Hart's comment about needing city planner, certainly, it might be beneficial if it was a city planner. He was agreeing with me that there was no planning basis for it. I think that's coming from me, and I don't know how to, that's coming from me. It's from my, I can't find how to, I have to.
It's some notification.
Yes.
Yeah.
But yeah, I think certainly.
The president did have one of the staff removed from his phone.
Well, this is my phone loaded up, it's my computer.
So,
But sure, yeah, but I do think a planner would look at it. It is, we can discuss a lot, the issues of housing shortages and everything. You're not getting any single family home application, or I should say any. You're getting very few single family homes applications, subdivisions. They're sporadic. The fact of having somebody having a rear lot with a size that it appears from the comments that this commission considers the rear lot, not all, considers the rear lot 1.5 times the size as some way of reducing density and reducing housing. So maybe it would be beneficial if there was a planner here to talk about planning tool, planning ability, and the fact of how it would impact people, and it would potentially increase, probably not a lot in today's market, but increase the number of new construction for single family homes. There are a lot of protections built in. There are a lot of regulations that were put in, your regulations or other regulations 30, 40, 50 years ago that are no longer applicable in the current chain. This is one, and I understand it. And the thing is, I draft regulations, I'm asked to represent people, and I have to do it. I did at one point, I will just say this, I did discuss whether or not this was something that could be brought up and discussed with your zoning subcommittee, but at that time, let's just say there were too many irons in the fire going on with the commission. This regulation, the regulation that you have, which other towns are beginning to get rid of, which is the number of families, the number of square feet per family that you have in your R4, R5, and R3 zones, which are passive and which turn neighborhoods into non-conforming use. These are all housing issues. But my whole point is, I don't think in a situation of increasing or decreasing the rear lot when there's no basically planning function for it, and do it, you're not going to have a bevy of It might be nice if you had a bevy of applications, but it's not gonna happen. But plus the fact that when you then go around and take out all those properties that are limited by wetlands or by cliffs or by your 25-foot slopes, 25% slopes, and all that other stuff, you're gonna cut into it. But the exercise that I did, it's, again, the ability to actually go beyond the number into which ones would actually qualify is something, no, I did it as a sample. I clicked a lot of subdivisions. And you might find, you know, it's depending on the neighborhood, depending on when the subdivisions would go. And stuff like that. But, yes, it would be nice to have a planner. And if the commission is interested in pursuing it, I'd be with the resident participating in pursuing. I think it's a beneficial. It's a benefit to the town. Increases single family.
All right, any questions for Greenhouse? All right, is there a motion to continue or close public hearing for this application? Okay, this one closed, made by Commissioner Apple. Is there a second?
Second.
Second from Commissioner Cristiano. So on the motion to close, Commissioner Perkins. Aye. Commissioner Apple.
Aye.
Commissioner Amato. Aye. Commissioner Ticky.
Aye.
Commissioner Cristiano.
Aye.
And chair votes aye, motion closed. Passed by a vote of 6-0. How would the commission wish to proceed in this application? Any discussion tonight or an upcoming meeting?
Oh, I would make a decision tonight. Anybody else?
Do you want to offer a motion?
I'll make a motion to deny the application. There's motion. This is more than a text change. I've had this conversation with Attorney Thomas multiple times. I'm not in favor of changing our text or our regulations to suit one applicant. I have no offense against any applicant per se, but just to change it for the sake of one application, just it's not a good thing for the city to do. It's not a good thing for this planning board to do.
Mhm.
Without knowing the repercussion of how it will impact the rest of the city.
And I need a second on that motion.
And Chair, I'll second the motion, and I agree with Parkinson, the lack of information being provided about the impact on the whole city really puts us in an awkward position of trying to vote for or against something. And I think we need to err on let's not change it before we know what the impact might be. So I would second that.
I can understand that concern. I think that's valid. I don't really see the difference between a lot that conforms to the size of the lots in the area to have, it seems arbitrary to me. It always has to have it 1.5 times larger, but the other point of wanting to see how it affects other possible properties and I do agree that we shouldn't make changes based on one particular person's case.
Sam, do you have any comments?
No additional comments that haven't already been made.
All right, I would agree with my fellow commissioners that there is just the applicant has not provided specific documentation as to the impact to the city. I'm very comfortable about moving ahead with this. Commissioner Ticky, did you have anything?
No, I agree with the comments from Commissioner Parkins and agree with the second as well. And I think it's been said.
Okay. All right, if there's no other further comments, I'll do a roll call. Commissioner Parkins? Aye. Commissioner Cristiano?
Aye.
Commissioner Amato?
Aye.
Commissioner Apple?
Aye.
Commissioner Ticky?
Aye.
Chair votes aye. Motion to deny application 2513 is passed by a vote of 60. Thank you. And this is science. And we'll move on to the public hearing for application 2516. Comments for limit submitted before 5 o'clock today?
It was submitted, it's just we haven't put
Oh, all right.
the papers.
All right, so let me continue. This is Dominic Thomas for CT 03 LLC at 1001 Bridgeport Avenue for a major modification to a PDD, modifying the statement of use standards to convert the current hotel use to a multifamily residential use with a maximum of 96 units and additional on-site participations. Commissioner Romano, would you need the legal notice, please? Sure.
Initiation of application 25-16, PDD number 8, Dominic Thomas for CT 03 LLC at 1001 Bridgeport Avenue for a major modification to PDD, modifying the statement of uses and standards to convert the current hotel use to multifamily residential use with a maximum of 96 units and additional on-site parking spaces. Plans titled amended final site development plans, PDD number 8, dated 7/17/2025, were prepared by Solely Engineering. The property is generally found as follows: northerly by 576 Huntington Street, westerly by 1055 Bridgeport Avenue, easterly by 965 Bridgeport Avenue, and southerly by Bridgeport Avenue, State Highway Route 8.
Thank you very much. This application was accepted for review on August 13th, posted on the city's website. Is the application for a major modification to a PDD, petition for amending the previously approved final site development plans, and statement of uses and standards, first amended statement of uses and standards, a letter from the property owner, which is an LLC, authorizing the applicant to submit an application on its behalf, site plans, floor plans, individual room layouts, traffic study, parking analysis, letters from the fire marshal and city engineer, 3 letters of support of the proposal, and certificates of mailing. Casper, are there any other reports, materials, or correspondence received within the time period for this application, but not yet posted to this website that needs to be acknowledged for the record of the Attorney Thomas? Okay, so Attorney Thomas, then first, record this evening.
Thank you very much, Attorney General Thomas, Conan Thomas, the Street, Connecticut, and the applicant. As the chair has identified, the notices and signposting photos were uploaded. Notices were sent out appropriately. This is an application to amend Plan Development District number 8, which is a 1987 approval, excuse me, for what was then an extended stay hotel called the Residence Inn, which is still referred to as the Residence Inn. It's actually owned by Grand Prix Shelton, and my clients, Blue Veil Capital and their LLC that is purchasing the property. Want to convert it into the 96 rooms into 96 apartments. In making the presentation today on Zoom is Luke Morrow from Solely Engineering, who will address the engineering, traffic, and other considerations. In addition, with respect to Blue Veil, Chrissy Martell will be making a presentation related to the handout we gave you, and correct, Sean DJ is also here with respect to the Blue Veil Capital. And they will go into and explain a little more about Blue Veil Capital's background. This is, they have done this and done conversions of other hotels. And it is something that is been considered in many communities to be beneficial. Beneficial in that you're taking it from one residential use to another. In the issue of the extended stay hotels, some of the concerns that have been expressed are that extended stay hotels have a tendency to have transient people coming in and out, and they tend to create issues. It is the intention here of the applicant to go in there, make improvements, and then by having the, studios and 2 bedrooms, that they are going to do, to then have individuals there who will be longer term, 1 year minimum, have been appropriately vetted and provide the type of housing that, as you can see from, if you read, and I passed out the packet, I'm sure you all read it, the letters there from Sam Simons of OEM Controls, Bill Purcell, and the other Lysick. And but I want to really focus, not focus, but would like you to focus on the letter from Sam Simons. I mean, I'll be honest with you, I had not met him until March of this year, and I met him at the CBIA, Connecticut Business and Industry Such Foundation function. And we had some very interesting conversations, and I will say this, that it was one of those meetings that I chalked up to a very educational session with him as far as the needs of the businesses. As you know, he's the head of, I believe he's the head of the Southwest Connecticut Manufacturers Association. And he educated me even farther on the needs of some of the employers for housing and the broad need. You'll have some comments mentioned here about this proposal is proposing 18% affordable units and 80% AMI, restricted in accordance with 8-30G for the 40-year proposal. And the client is rounding off the number at 18 units. In other words, rather than,
19,
19,
rather than the accurate number of 20%, it would be 19.
well, this commission could ask whatever, for whatever, which the 18% was obviously taken from your, I take the percentages that's in your housing, affordable housing plan.
Right.
I took
But it's
that
at 80%, correct?
at 80% AMI. Yes, these are the 80% AMI. And anyway, but in addition to that, I think, and they can elaborate further, the actual rents, the market rents will be along the lines of what they call the workforce housing type of rents when you consider the aspects here that will be involved. The impact, the amendment to the statement of uses and standards had two amendments in it. One was to go to multifamily rental residential, and the other, based on a preliminary discussion with this, related to increased parking. And that one, which was, let me, hold on a second. Screen share it and just point it out to you. Really helps down here. So. So this is the amended statement, the first amended statement of uses and standards. And it, the amendment and the permitted uses. Just so you know, the 1987 version of the statement of uses and standards was not numbered like the ones you have now. So I just basically inserted, tried to follow as best I could as how it flowed. And multifamily residential at a density not greater than 96 units, 18% of the units be rented out below the 80%. Median income, as required by 8-30G. I then put one in that said parking shall be at the rate of 1.0 space per studio, and 1 bedroom and 1.8 spaces per unit per the 2 bedroom units, which we took from a parking study that was uploaded and which will be discussed by Solar Engineering. And then in the setback line, and there was a 10-foot setback on the parking. And I provided that the commission may reduce the setback for parking based on existing or proposed buffer, location of any residential building, or the existing topography along the property. As you will hear from Solar Engineering, this property, believe it or not, has quite a bit of ledge in it. And therefore, to expand, when I was drafting this, when you're viewing a two-dimensional site plan, it's a lot different than when you're looking at a cliff. And so in viewing the two-dimensional site plan, we thought there might be areas where you might be able to reduce the buffer. It did not turn out that way. So I just wanted to make that clear that that wasn't necessary, you know, in the end, after Solar Engineering got done. But originally, when I applied for this, that's why that was in there, to see, give the commission some discretion to possibly do it. The letters of support speak for themselves. I think it's very beneficial. I do know, and it's a matter of, shall we say, street talk or whatever, that there have been some issues in the extended stay hotels. And this type of development, changing it to that, provides an amount of housing. You're going from one form of housing to another form of housing, but now you're going to be in a situation where the tenants are signing longer term leases and are vetted more appropriately, as you will see. We're also going to see improvements to the site, to the physical improvements to the outside, and I leave that to Chrissy Martell, who will develop it. So overall, when you consider the use that's on the property, when you consider the needs for affordable housing, and when you consider the needs as expressed in the letters of support, especially from Sam Simons and from Bill Purcell, your executive president and executive director of the Greater Valley Chamber of Commerce, I think it's a very appropriate use, beneficial to the town, certainly, and would actually probably result in a substantial increase in the valuation of the property by the change of use. And as far as impact upon infrastructure, it already has a specific impact residentially on the sewer, so that the change is not going to be anything substantial or anything. So,
The bottom line footprint of each building is not going to change.
Correct.
The activity that's going to occur is all interior renovation.
There will be some exterior improvements done. There are areas, I'll let Chrissy go into that. There are areas around the building that do need to be upgraded.
Right.
I mean, the example you will see is
Add additional floors.
Oh, no, nothing of that nature. You know, going in there, for example, I think you'll see a discussion that one of the improvements is to take care of, if you're driven through it, the dumpster area and dumpster back, which is not in good shape.
Okay.
And but anyway, if there are no other questions for me, I'll turn it over to Chrissy Martell from Blue Vale Capital to discuss the client, their background, which I think is very important for you to understand, and what they intend to do with it. And then we would go to Luke Morrow from Solar Engineering.
Okay. Just another mic.
Oh, sorry.
Good evening. My name is Chrissy Martell with Blue Vale Capital. I'm the Director of Stakeholder Relations at the firm. My address is at 335 Orange Street, New Haven. And I'm here with Blue Vale Capital. We are an ESG focused real estate developer and investment company. Environmental, social, governance focused. So, and I can get into that. We're specialized in real estate conversions. We take underutilized commercial buildings, such as hotels, office buildings, retirement homes that are blighted in some cases, and we convert them to residential communities that can, benefit the local community The firm has converted over 510 units. We currently own and operate 715 unit multifamily portfolio in North America. So that includes Toronto, Canada is where we're based, and we have an office in New Haven, Connecticut. Our mission is to create vibrant communities and provide sustainable housing solutions across North America. So as you know, this particular site, it's an adaptive reuse project. It has a positive environmental impact component to it, given that we're not making any changes to the footprint of the site, right? And in doing so and bringing affordable and attainable housing units to Shelton, we're able to do it in an environmentally friendly way, because through these projects, we can reduce emissions by 80%. We've been in communication with members of the Shelton community, the Greater Valley Chamber, Bill Purcell, Dominic mentioned, folks such as OEM Controls, Sam Simons, and also some nonprofits such as LISEC and Team. LISEC, LISC, it's a local Connecticut nonprofit.
Really, they say, I haven't heard.
Yeah, so
I've never heard of them
yeah.
either.
So Phoebe, you want to just.
They were one of the list, right?
Yeah.
Oh,
James Ford is the senior executive. So they're out of Hartford. So we've been in communication with several members of the community and businesses, and our understanding is that there is a need for housing options for your young professionals just starting their careers, either in one of the major industries here, manufacturing, healthcare, and there's really a dire need for housing options for couples, young professionals starting their career, given that the housing options have become increasingly expensive in Shelton in recent years.
Also, one that part of the packet that we presented to you, there was a request made. And we were presented with the floor plans that were approved back in 1987. There's no change to that. They were reviewed thoroughly by Bluevale and everybody, and they were a little confusing to read. I think back then they were more drawn by hand. You know, by the so they got to be a little confusing. And so basically, in the packet you were given, you have the floor plans. There are 4 different, I think, type of studios.
Yeah.
87. They scratch my head a little bit as the penthouse units.
Yeah.
And
The ones where the bedrooms actually have a door.
which are also 2-floor. And I can honestly say that is the only unit I was in when my sister-in-law and her family years and years ago came and stayed in the residence inn, and they stayed in one of the 2-floor. Those are referred to as the penthouse units. So the breakdown is 72, I think.
72, 24.
Yeah.
Yep, and 24 2-bedrooms.
2-bedroom units. And do you have any questions about Bluevale? Chrissy's here.
the layout of the typical hotel room, out of the elevator, walk corridor, these are all coming from the outside. They're like townhouses.
So what is the average
So, well, I don't necessarily have any issue with the proposal. I'm having such a hard time wrapping my head around all of this talk about workforce housing and affordable housing. And it's not affordable. And that's my point. It's almost like it's a game. It's a guise to get more housing, but it's not affordable. So if you take our median income of Shelton, and from what I've got in front of me right now, I'm going to take an average of $125,000, right? Times 80%, that's $100,000, right? Why would somebody that's making $100,000 need an affordable unit?
Well, first of all, 80% AMI is not computed.
But
That's not the way it's computed. There's a formula that the state has for 80%. You start out with the average income, and Shelton is in Bridgeport. Shelton, I think the last time I checked it was
Yes, so at 80%, it's in the packet, page 9. In Shelton, and this is from the Connecticut Housing Finance Authority, one person to qualify for the 80% of AMI in Shelton would need to be making $63,680 with, as one person. At that level, their rent for a studio would be $1,592. I want to point out that the folks in the top 3 industries in healthcare, manufacturing, and educational services here in the Shelton community, many of them are actually under the $63,680 income per year. Your medical assistants make $43,000 a year on average. Your electricians are making $61,000 a year on average here in Shelton.
And so how are they going to afford an apartment that's $1,600? Is my point. You're saying at the median income, 80% AMI would be about $1,592. That's $1,600. How is somebody that's making $50,000? How can they afford $1,600?
They would be paying $1,592 for a studio.
Right.
$1,600.
$1,600. And they're making $48,000, right? That's, it just, the
No,
math
I
just
don't
doesn't
think-
add up in my head. Maybe it's me, but.
I don't think that, first of all, the computation for we're not talking about, this isn't the American, this is the state. This is the state rate.
I get it, and I.
This is the question of whether or not, and the workforce housing runs from, first of all, workforce housing, the way they define it at the state level, runs from 60% AMI to 120, I'm sorry, 60% AMI to 120% AMI. Okay. And there are 2 things operating there, and they should pass out the CBIA extensive report that it did. One of the 2 things that are involved. Number one, it's been proven nationally, and it's been proven in several other cities, that rents can be stabilized by increasing supply. And Shelton has probably taken a lot of steps towards that, stabilize it if you increase the supply. But in the rents that have been established by the state for the 80% AMI, and if you look at what is being anticipated here, in addition for the market rate rents, and these were discussed with the individuals who wrote the letters, the market rate rents are going to be able to be close to the workforce housing numbers also. These numbers in this place are not going to be similar. Well, first of all, you can't be comparing the rents that are in the market, because that's a whole different, that's a whole different concept. With a brand new, huh?
That's not.
Yeah, you're right. And even with the newer, when you're talking about the newer buildings that are going up and out of situation. But in fact, what this is, you are getting the 1820 units that are going to be governed for 40 years at the 80% AMI. And it may be that this
82
commission
units, Attorney Thomas, but we're out of that out of the 96, we're getting 18 units, but we're adding 70-something units to our count, right? So it's never, we're never gonna reach it, never gonna reach it, and it's not.
Nobody will reach.
This is the cap. 1592 is the cap under the current statute. That doesn't necessarily mean that's what you're going to rent the facility for. I don't know what your metrics look like to do that, because I think to Commissioner Parkins earlier, if you're making 43,000, you're not paying 1,600, you're just. Okay, so the question is, and you don't have to answer me, but at some point, I think you have to figure out if you're really gonna follow your social statement on your website. Is 1,600 the right number, or do you
Or is it just
play
marketing?
some number less than that?
The marketing.
Right. The second question is, could you do the whole thing at 80% and make that work? Could you provide 96 units at 80% and make them had a return on your cap? Because I understand you're in business, but you also stress that you're social equity.
Well,
So the,
well, let me, the first response, because this happens, because I sat there when Michael Santoro. Sitting right back
Let's
there.
not even bring him up for
Okay.
this.
All right, well, but what he
I
said.
asked her. I'd like her to answer.
Okay. I'm answering I'll answer the 10% issue.
so our market units are going to be at or below the workforce housing limits. So in Shelton, that means 120% AMI. Pricing for studios is $2,388. 2 bedrooms are $3,072. So although we're doing 18 units, it's affordable, the remaining market units are at or below the workforce housing limits in Shelton.
That was my question.
Are you looking for exact pricing
No, my question was,
at or below?
That is what.
that's workforce, that's the definition of workforce
Workforce
housing.
housing.
It's a crazy number. It's absolutely crazy. number.
And
It's not my fault.
To give you an idea, the comps like Metro on Broad, the only other
Where's that?
that's in Milford. It's the only other property that has studios within, it's 8.7 miles. Their studios are priced at $2,095. Star Deluxe in Milford,
They're not getting
$2,295.
funding from the state to offset, so that's.
Well, neither is that.
We're not either.
They're not either.
You're not taking any workforce.
No, this is not Bill Connecticut. This is
Okay.
not Bill-
Putting in our own
In
act.
fact, they wouldn't qualify.
My other question was, could you do all 96 units at 8%? Would the math work? I mean, number one, it would help the city tremendously, because we would get 96 units that we get to count towards our 4% goal.
It's not adding to our.
Right. As Mr. Parker said, we get 18, but we lose the balance. So we take a half a step forward and 3 steps back every time somebody builds something.
You're not gonna find any developer that's gonna, that without a subsidy.
They're a social equity company.
Madam Chair,
Go ahead.
before we go down a rabbit hole, in my experience, we haven't queried any applicant presenting a change on prices of apartments. I think it's inappropriate to continue this line of questioning to an applicant. I don't wish to be part of it.
I actually agree with you. I mean, we haven't asked anyone else to do. more than this.
And it's not even the dollar amount, it's just the fact that this is a marketing. And I'm not against this applicant.
Yeah.
Say, just in general, this has just become a game.
I don't disagree with the concept, but it's not this applicant's fault of what the state is doing. And I don't disagree with anything you're saying. It's problematic. I totally agree.
It's just so
But
frustrating.
I totally, I agree. I agree that the city is not gonna be able to reach our 10% threshold, but it's not this applicant's responsibility to solve that for us.
All right, point taken. Continue on.
It does provide housing, it does provide a break for some people, because 18 people, they get a little break. on their costs.
I think the
I mean, that's-
concern is just on the surface, it sounds good, but in reality, it's not necessarily.
Well, big
And
huge housing problem.
Benefits of you,
Yeah,
that's the key,
yeah.
not the masses, like the state is saying. We would.
Okay, so let's get back to the topic at hand.
Okay,
May I share some research?
Sure.
Yeah, so, the Connecticut data collected, looked at Shelton. We found that 48% of renters in Shelton are cost burdened. Meaning, the guidelines from the Federal Department of Housing states that households should pay no more than 30% income on housing. So as I mentioned, 48% of renters in Shelton are cost burdened. 24% of owners with mortgages here in Shelton are cost burdened as well. And we hope to be part of the solution in providing housing for the seniors that are cost burdened, right? And that are unable to pay for their prescriptions or doctor's appointments because they're cost burdened. And also renters that are cost burdened, such as young
So
professionals.
Shaw Cross said you would have a more economical place for them to live than where they presently are. Your rental rates would be cheap. And that will help them in the long run because they would not have to spend much to their budget on.
one of the things that Jeff and Sam Simon and I sit on the steering committee to establish what the CBIA housing. We had our first meeting in July. And one of the reasons, in the discussion, this is a mixture of business people, owners of multifamily, but a lot of business people, a lot of people from CBIA. We're not talking about a relatively liberal organization and talking to them. They did a report and they have studies. People can not with them, but they did a report and they had 2 studies done on Austin and Houston, where the rents were going sky high. And both of them went, and I'm sorry, one also I think in New Jersey. What they found out was that when they went into the building boom, and I mean building boom, the numbers that you don't see around here, but when they went into the building boom did not lower rents, it stabilized. And that was the most important thing. The rents were going up at percentages that were really unsustainable, but by creating an enormous amount of supply creates the small A for it. And that's what happened. Doesn't mean rents are going to, it means rents are going to stabilize. They're not going to go flat. As far as your 10%, I spent a year of my life as the chairman of the Woodbridge Affordable Housing Committee and going over it. And that was a question that was asked. And I'll be honest with you, all the experts that they provided us with that the SCOG told us, you'll never get, it's not a question of getting there. That's not the point. The question is by increasing it. The other thing is with a lot of the people that are Alice change, which is the terminology for those people. Those people, many of them, and there are programs out there, and the governor just heralded one. These are fully subsidized. There is a group of affordable housing that is fully subsidized by chapter. It's not Bill CT. Bill CT is a different kind of subsidy geared towards the workforce. So sometimes when you're having a conversation about it, you're cramming everything into a single ball. It's not that. There's a very broad range, and there are people that do it. So I think that the advantage of this, focusing on this project, is you're talking about a site. There's nothing wrong with extended stay hotel. They have a good reputation sometimes because of their transient nature. And now you're going to take one, and you're going to improve the area. You're going to improve and you're going to create housing. And one of the reasons why Sam Simons wrote this letter was that in talking and understanding what was going to be done, he was going to be addressing the various levels of the people that wanted to bring in. They don't talk about when this is talking about bringing people in. They're not talking about it just one time. And I remember sitting there listening to him and getting educated by him. He was looking at the $40 an hour employee, where are they gonna live? Trying to get them to come in. They have 77,000 jobs openings in the state of Connecticut. And we can't fill, we can't bring in people to fill. So he would talk about that. So then there's the 65,000, at 65 an hour. So,
We get that. Can we please get into your
Well-
traffic study? and your-
well, we can move to it. We're addressing the issues brought up.
And I think you should be commended for offering to do this as opposed to be mandated. It's great, that's why I asked you to do more.
I think we can, if there's no more questions, we can move to Luke Morrow. Who is online, he will take care of the engineering, traffic, and the park.
Good evening, everyone. I'm just going to share screen. Give me 1 second. You know if everybody can see that.
It's coming.
Okay,
All right, we have it now.
perfect. So for the record, my name is Luke Morrow. I'm a professional engineer in the state of Connecticut, also a professional traffic operations engineer. I'm a senior project manager with Solely Engineering, 501 Main Street in Monroe, Connecticut. So just want to briefly walk everybody through the site plan related changes. I think it was alluded to, there's not a substantial amount proposed as the site's developed in really relatively good condition in terms of the site improvements, but we'll just talk through what's proposed and some of the increase in parking that we're providing. So currently the site consists of 96 units formerly as an extended stay hotel. There are 106 associated existing parking spaces on site, and we are proposing to increase the number of on-site parking spaces up 14 spaces to 120 total parking spaces. That's six. There will still be 6 ADA parking spaces to remain on site, which is still compliant with that increase in total parking. So we did submit, for the record, parking justification memo contained a bunch of information from ITE, which is the Institute of Transportation Engineers. We use that for both parking generation estimates and also trip generation estimates for all different variety of land uses. And we also looked at ULI, which is the Urban Land Institute, which unlike demand, which ITE kind of goes and says, okay, we counted this many parking spaces, this is the demand. ULI gives more of a recommendation and empirical data on the supply rates, which is how much parking is provided, not necessarily used, but how much parking is provided for a variety of different land uses. So based on information in ULI, and you'll see in our report, we cited both ITE again and ULI. ULI recommends for studio units 1.0 spaces per unit. That's broken down by 0.85 spaces for the residents, and then 0.15 spaces additional for visitor parking. And then for 2 bedrooms and larger, 1.8 spaces total. And again, that's 1.65 spaces for the residents themselves. And then I guess an additional 0.15 spaces for visitors, with the assumption there that obviously not everyone's going to have visitors, at the same time. So based on the ULI parking demand data that we supplied, we came up with these. We're utilizing basically, we're utilizing the straight rates that they recommend for what should be supplied for a multifamily development such as this. The total required parking would be 116 spaces for these 96 total units, and then we're actually providing 120. So we were able to squeeze a few more parking spaces on the site over what ULI had recommended. Dominic had mentioned, although the site horizontally looks like it could fit more spaces, I just did want to cover briefly the reason why that is kind of challenging. I think anyone familiar with the site can see the parking, and there's a retaining wall up along the road. It's fairly close to the road. There's no room to fit any additional parking along the perimeter, along Bridgeport Avenue, and then along the old Langanke parcel here. as well, which is on the southwest corner of the site. And then as you traverse along the rear, although we are getting kind of close to the property lines there, there is exposed rock face up to call it 15 to 20 feet tall. And I'll show some pictures in a second, which although tight horizontally may be able to fit some spaces there, but because of that significant change in grade and the exposed ledge, it's just not feasible to put any additional parking there. So we did find some flat spaces on the site adjacent to the pool and the pool house building, kind of in the middle of the development in the rear there. We're able to squeeze in an additional 4 parking spaces with pervious pavers so that any additional runoff could just kind of percolate into the ground there. Some green infrastructure, reduced any impacts associated with additional stormwater runoff. And along with that, that would be curb with a 6-inch concrete curb, and then a sidewalk would be where the sidewalk was adjacent to the old parking lot. We would just reroute that around the back of the proposed spaces. One addition. Go ahead.
Talking about there are going to be pavers. How are you going to line that area so that you don't have somebody's taking a space and have to be going correctly?
I'm sorry. It was difficult to hear the question. If you can.
In that area where there are pavers,
Okay.
how would you be treating it so that there are 4 spaces? Are you lining them, or are you going to have car stops or something to show?
Yeah. So it'll be surrounded by a typical 6-inch concrete curb on all sides, and then they would be, it would be, a brick paver that's got some, it's got some void space in between, but it would be striped with a regular 4-inch double painted white stripe, parking line, just like the other pavers would be. So they would be. It would be clear that there are 4 striped parking spaces there.
Only because this is pavers and not.
Yep, no, understood. Yep, but the material will be such that it's stable for cars to drive on, but it would allow percolation, but you could certainly stripe over it as well. Understood. And then one additional parking stall on the corner where there's some flat area adjacent to the Langanke parcel in the western side of the site. And then on the northeast corner of the site, kind of adjacent to the dumpster enclosure and where we're going to be removing those sheds, we were able to provide an additional 9 parking spaces with pervious pavers. Again, they would be striped, and there would be a 6-inch concrete curb surrounding those parking spaces as well. Can kind of see here on my screen, you can see the topography lines here. Probably easiest to see the bold, not the dashed lines, but the solid lines. Each one of those represents a 5-foot change in grade. So you can see quickly as you get off the edge of travelway into the wooded area, you're dropping 5, 10, 15, 20, 15 to 25 feet. So trying to provide additional parking without, constructing a significantly large retaining wall and rock cuts would be tremendously challenging for the site. And frankly, based on our information, it's our opinion that it doesn't really require any additional parking over those 120 spaces that we're proposing. Although a little bit difficult to see here, I will show a few pictures. This is the area where those 9 parking spaces are. Generally flat, but you can see the exposed outcroppings of ledge over here. And then if you go to the street side along Bridgeport Ave, probably much easier to see here. We're talking about, quite a large change in grade right off the travelway in the parking lot there, 20 feet or so. So again, horizontally speaking, is the room? Sure, but vertically speaking, with all the ledge and the extreme slopes on the site, very challenging to provide any additional parking over what's proposed. In addition to the increase in the parking spaces, a few other site-related improvements that the applicant will be pursuing and is agreeable to doing. There's the existing enclosure itself is in a little bit of disrepair. It's a brick enclosure. They'll be repairing that dumpster enclosure, as needed, remortaring bricks leveling the walls out, whatever's needed to fix the enclosure there. I believe the gate in the front is broken, so the gate would be repaired in order to avoid residents having to open the large gate in the front. We're proposing a small concrete pad that'll be at grade, so ADA accessible, if you will, from a parking lot as well, with a little access door so they can get in, access gate, sorry, on the side there to access the enclosure itself. Right now, the enclosure has a compactor in it. That's going to be really not necessary for a residential type use. I'm not quite sure why it's there for the hotel, but that'll be removed. And then the dumpster, which is located outside the enclosure now, will be really relocated inside the enclosure so that it can be screened from view. So repairs, and aesthetically speaking, it'll be repaired, and then that area will be cleaned up. There's also a shed or two over there that'll be removed as part of the site work related.
Tomorrow,
Yes,
to confirm, there is going to be an enclosed dumpster that through some kind of separate doorway, tenant could go in and throw a bag of garbage in.
It's called a panicle.
Yes, I know. And then also the gate would be for garbage trucks coming and remove.
correct. Correct. The gate would be mostly for the truck that's coming once or twice a week to pick up the trash. But in terms of, because it is fairly large, I mean, it's a 12-foot wide opening. It's a pretty large, heavy gate. So we would be putting in, like, I call it a 36-inch wide access gate on the side, of the brick wall there, so that it's more manageable for a resident to open it and throw their trash inside the dumpster.
Was there any consideration to add a second dumpster site on the other side of the property?
We have, I'll be honest with you, it's not my expertise in kind of evaluating the needs of how much refuse is required for a development such as this. However, if amenable to the applicant, there is space there to widen that a little bit if the applicant is willing to sees a need and is willing to do that. However, based on the information we were provided, we understood that the single dumpster provided enough capacity for this development. But I can certainly, I guess I would refer that question to Chrissy if she's got any comment on that.
It's just a matter, it just occurred to me, if you have a use now that maybe a little bit, going to be populated a little bit more than was as for then, I'm not sure, because I'm not on capacity numbers or use numbers, but that just occurs to me.
Yeah, it's a matter of convenience, because if you only have one dumpster enclosure, you're gonna have people that are gonna take their trash bag and put it outside your door at night. They don't want to walk all the way to the far end of the parking lot to get the trash out, so I don't think I need to tell anybody what having trash outside your door leads to, beside critters and
Sure.
bugs and whatnot. So it might be something we might want to consider.
Okay.
Practical matter, you added one parking space on the other side.
Yeah.
You've got more parking spaces than you need. That may be a practical place to put a second dumpster.
Okay. Yeah, understood. I mean, if it's, as I said, if the applicant is amenable to it, we can certainly accommodate. If it
Would that be something they could determine with use? Parking to me doesn't seem excessive,
No assessments.
and to require that they remove parking.
No, it's not required.
I'm just
I just think it's a matter of convenience that tenants would definitely appreciate it.
That would be a
It could offset a lot of other issues that could arise in an apartment that I've seen.
Okay.
Anything else for us, Mr. Morrow?
Yeah, just quickly, in terms of, I think it's worth noting in terms of safety related improvements. Looking at the site, and we did visit there a few weeks back, it looks like the stop bar may have faded away, and there's no stop sign at the exit. So we're proposing to, repaint that stop sign or install it if it's not there, and then also install a 12, a stop sign as well, for vehicles exiting the site. Probably worth noting, we did do a quick traffic study. It does indicate that, the driver will operate at acceptable levels of service. For what it's worth, the trip generation of low-rise multifamily versus a hotel is slightly lower. I mean, for argument's sake, we can call it apples to apples. So if the hotel was fully operational today, the trip generation change is negligible. It's not much different than it would be today. So there would be no additional adverse traffic impacts as it would function if it were a hotel. I think with that, that kind of concludes what I had. And if there's any other additional questions, I'm certainly here to answer. Be happy to. Thank you very much.
That study I mentioned is very important to note that we're actually right outside the door, and if you would right outside the property, and if you recall from your improvement of Landing, there's a bus stop there. And I think Landing final approval requires Landing Landing to put a bus shelter at that point. So there will be an access to it, and if you look at the traffic today, I believe it shows that is the route that the individuals there would be able to go right down to the Bridgeport bus station, which is the Bridgeport train station, and across the street there's a stop, which would mean anybody would be able to go to the train station.
Will there be a rental office on site?
Yes, there'll be a leasing.
Leasing office, correct. So typically 9 to 5, something like that, or is it staffed 24 hours? Just thinking about in terms of parking and additional consideration.
Yes, so there'll be a leasing agent there, 9 to 5 regular business hours. There'll be actually 2 maintenance folks, and they work weekends as well. So they'll be on call and available.
They're on call all the time, or they're
So there'll be 1 maintenance person always there,
On property.
7 days a week on property, and we're hiring a second maintenance individual just to come in, just one.
So at least 2 during the day, at least 2 staff people. Parking cars. Using cars for people that work. Using, not parking people's cars, parking their own cars. They're on site during the day.
Right, so they're using 2 of the
Staff.
spots.
Yes.
Yeah, okay.
Assuming
I'm the new kid on the block, so doesn't Shelton have curbside recycling?
Yes, it does, but this is
This is
private
private
development.
development,
So they have to.
the city doesn't provide trash
I
or.
realize that, but does the complex recycle?
Find it. Find it.
So how do you accommodate that?
In an apartment complex. Yeah, they have a trash room. Right where the.
I thought Connecticut had a mandatory recycling law.
I don't know if it's mandatory.
I don't think it's mandatory.
We'd be happy to recycle. We are making, the dumpster enclosure repairs with the new access gate. So I'm thinking we make that enclosure bigger, since some of the bricks are falling apart anyway. We just make it larger, have recycling and dumpster in that enclosed area.
Just to show you,
Yeah.
the brick enclosure matches.
Yeah.
Which was
Sure, then we
very
have to-
common all the way back in. There's dumpster.
Just make a note, whatever we've done, recent applicants having dumpsters. I don't recall any conversations with dumpsters about having separate recycling bins. So whatever we've done, in the past, as long as we do it moving forward. I'm fine with that, but again, we haven't talked about vision of garbage.
Yeah, no, but, never mind.
These amenities, this gym and pool, those are currently there? They're not
Correct.
changing those or?
Gym and pool, we plan to keep the existing amenities, and we plan to upgrade the machinery in the gym.
You have 72 studios proposed for this facility. I see you have studios in Stratford. How successful have you been in renting the studios in Stratford?
Let me clarify, we do not have any, the only other property we have in Connecticut is a 42 unit retirement home that we are looking to convert to multifamily.
So
It's
we
So
see
39
examples in here or not?
Examples are not yours?
So the examples that are titled CT conversion. We have Blueville's Connecticut project at 39 Highland, and then the hotel conversions to residential Connecticut case studies, not Blueville.
Got it.
Were just examples of hotel conversions being a strategy used in Connecticut to improve underperforming hotels to multifamily.
Okay, what's next, Frank Thomas?
I think that concludes our presentation unless there are any questions or anything with respect to that. It's relatively.
I think we should just note for the record, we did receive a positive letter of approval from engineering and the fire marshal for what it's worth.
Well, those items were.
Okay.
Version and something that has happened. More roads.
You have WPCA approval?
WPCA, if they're already connected to the WPCA. So my only involvement with WPCA was call them because I guess the seller not provided the WPCA fees that pay their vehicle. There's a sewer use charge right now. So you're gonna have in other words, you're just changing. You're not changing the use, it's residential to residential. And they already pay, they had the last year and I looked at, yeah, I think it was the last payment.
Is it per unit?
20,000. Yeah, I think it is. See, Shelton does not do usage. So Shelton does not do like workspace and water usage, which I know has been a
Yeah, I know
discussion.
single users.
Yeah,
trying to
right.
get burned.
So I just ran the numbers, 20,000 some dollars. I just divided it by 96. You know, just arbitrarily, which isn't correct. There's probably another bathroom for the office and everything like that. It came out to 216. I think it is 220 or 221, something like that for the commercial. So the payment.
Per unit.
Yeah, I mean, that's what I did. When you look online, the payment is $20,000. You know, $20,000 something dollars was their.
Divided by 100.
Yeah, I was dividing by the 96 units, then saying, well, wait a minute, there's also a bathroom in the office and like that. So I just ran the number just to see what it was, and it came up 216 around 20. You know, if you add the other bathroom.
You're not dividing electrical. Submitting, correct.
Yeah, we are submitting the electrical and the water.
You are.
Yeah.
Okay, sorry, you're what?
Submitting.
Separating.
Yeah.
So the tenants are responsible for paying the septic and the.
Per use, so we're not discriminating by the unit type, it's gonna be as much as you use, that's the utility bill.
Oh, usually units metered?
Yeah.
So they're
They're
individual
gonna get their
bills.
own bill.
We're going to, so each building has a panel, we'll be adding submetering for each of the units.
So each unit will.
They'll pay their own
Or-
electric.
They'll pay their own
Yeah.
water.
So they have to go pay their own water as
Yeah.
well.
All right, if there aren't any questions for the applicant, then we need to public portion and if there's someone that signed up, but if there's anyone here in the audience that had not, please step forward. We'll start with the elected officials from the city here in the auditorium. It's here. If you are an elected official and you are participating remotely, please use Zoom, raise your hand, please, with dial star 9. Anyone here? No. Okay, so we will sit here. Jack,
We'll get rid of them.
We'll turn back to, those in the public who are here participating. So, Paula, just go ahead and, identify yourself for the record.
Okay, Paula Dressel, I'm at 586 Huntington Street.
Mhm.
My property is, here's Lang Yankees, mine's all the 300.
What your content?
Okay, 260 feet along that wall.
Mhm.
It's been there since it went in. It's a 5-foot privacy fence with a buffer. I want to make sure that the buffer on your side isn't going because people now throw garbage into my yard over the fence. And that's just workmen that come in and park in the parking lot, not people that are staying there. Usually the people that are staying there are there on weekends. It's a wedding. It's just groups of people that come intermittently. I don't think transient, it's not, I've never had that impression. It's kids that are doing parties or whatever. But I'm worried about the buffer. I don't want it to go. Also lighting, now there's one light in, I've now gone up into the second floor of my house where I've just only been there for 4 months up on the second floor. The light, when the trees are empty, there's light that shines right into it. So I know that you're gonna add probably more lighting along the parking lot. I don't want it into my yard. It's on all night, it's on all the time. And that goes for the Langanke property too, which I was here, they were down there. So, and what I had a question was, because he had changed it and it said, provided the commission may reduce the setback based on the existing or proposed buffer. I don't want to reduce that buffer. And if they're talking about taking some of it away to put parking in that corner, that's my property, that's the end of my property, and I don't want a dumpster there either. So that's it. I don't think there's any say that it's me going, it's not gonna happen, it is gonna happen, but those are two big things that I'm concerned about as a property owner. And if there is gonna be somebody there to manage like the noise, I mean, is there gonna be a 10 o'clock where there's no partying out in the parking lot? It's renters, it's gonna be different kind of people that are there. I don't care that they're taking a year lease, it's still gonna be in 2 bedrooms. You're gonna have kids, you might have teenagers. I don't think it's even enough parking. If you have that many, probably there's gonna be 2 cars for the 2 bedrooms. That's what you probably have to think. And at least 1, maybe 2 in the studio, because it might be couples. That's a lot of parking, that's like 200s. I don't know, with guests, I know you're gonna need more parking. I just don't want it to be in my buffer. I want my buffer to disappear and get more lights and more everything into my yard. Okay. I have the biggest property line along the property. Yeah, that's it. And privacy and lighting and all that.
Okay. Right, Nadia? Anything else?
No.
Okay. Hey, Tom, want to come back up? Is there anybody else in the audience?
That's it.
Okay. And let me just ask, is there anybody from the public who is participating remotely on Zoom or through phone link? And you want to comment, please raise your hand picture or dial star 9. No, okay. All right, Jerry, now the floor is yours to comment.
Yes, and I would defer to Luke if he, if he has any of the extra pictures. I know when I drove around, there is a wood fence that does wrap around a bit. Certainly, any of the lighting that's required to be on the property would have to comply with the down lighting and would have to comply with those fixtures. I will defer to Luke on that. I recall, the concerns that were expressed at the Langanke's landing. Property is basically 2 properties like this, and this is the property we're talking about. But certainly, yes, the lighting would be required because we are changing the use to comply with the lighting issues. I defer, I'm not sure whether people here, or Luke would be appropriate to ask what lighting we're gonna add or correct. To the building, it would be Luke. Okay, Luke?
Yeah, so, well, I think twofold too. I know, if I understood, I brought the screen share back up. If I understood, I believe, this is the property in question. So, I think as an act of good faith, understand the concern with the buffer. The intent is to not reduce that buffer. So what I could say is, we can, given the concerns, I think we can probably eliminate this one parking space so we don't push that payment line any closer and relocate it to the opposite side. I don't think one extra space is gonna kill us, on the
Where's
sides.
the-
So
Could
I
you show the 10-foot line? Could you go back to her space and show where the 10-foot line is? Because that parking space doesn't encroach upon the 10-foot line, right?
No, and this is actually shown, the line you see here it's shown as a 20-foot buffer. So that's actually outside of a 20-foot buffer line there. But we're, the closest pavement, if you will, is all the way here in the corner, and that's about 25 feet or so away and about 20 feet or so from the fence. So I think I would say we could certainly agree, as a condition of approval, just to relocate this one parking stall so that, we don't get any closer to encroaching that buffer within the neighbor's property. I'm sure she would be very thankful for that. I don't want to put words in her mouth, but I think that would be an easy change to make. In terms of the lighting, I don't think there's any, as far as we're aware, the on-site lighting is adequate. I would say this, if fixtures do need to be replaced, they would be replaced with newer energy efficient LED fixtures. We all use dark sky compliant. All the lighting is recessed so that the LEDs are up in the fixture. You can't see the bulb, below it itself. So, when and if the time comes for those light fixtures to be changed, they can certainly easily be changed with LED light fixtures. But we're not proposing the installation of any new light fixtures within the parking lot itself.
Well, that would be new additional ones, but how about existing ones to make sure that the light is not spilling over onto adjacent properties?
Well, plus it should be, lighting that's ESG.
Yeah, I think that whatever the specific light is, the lights are going to be made compliant with the night to light, whatever the down lighting. But if at some point you can speak to her and have her identify for us the specific light that she is referring to, because I think a lot of the lighting, if my memory serves me from driving around, is on the buildings.
Mm-hmm.
I think there's lighting on the buildings, and it may be one of those that is, remember, we're talking about 1987, there was no down lighting or anything like that. So once it's identified as to what specific light is, if it has to be removed, it'll be removed. If it has to be just changed to be down lighting, it will be done. There will be no light shining off onto the property.
Do you plan then to submit a lighting plan? Like other applicants have that show?
You mean, well, this was an existing property and we weren't gonna
So
make.
there's no improvements.
Yeah.
For lighting.
Yeah, there was none that, other than replacing something, in other words, any of the lights that weren't functioning properly, just to replace them.
So you're,
Yeah,
i.e. you're gonna replace light bulbs.
right,
Not.
not put in new, at this point, not put in new light, yeah.
No,
So
but then-
there's not gonna be really a lot of renovation. So,
The reason
But you-
I'm bringing up about the lighting is so that it is on the record and on file somewhere.
Right.
This is where those light fixtures are gonna be, is what's gonna.
Could you talk about the renovations that you are gonna be doing?
Yes,
So renovations and upgrades to the site, we're gonna, as mentioned, we're gonna do a dumpster enclosure, repairs, new access gate. We'll be replacing, the broken fencing, around the HVAC condensers. We are keeping the fence separating, her property with the site. Correct. We're keeping that
in good repair.
Yes, keeping it in good repair. So if there's rotting wood in parts of it, we will repair that and make sure that that barrier exists. We are going to be repainting the parking lines immediately and addressing the potholes on the site this season, and we will fully repave next season. That is the plan. In terms of interior upgrades, we're just repainting the unit interiors, and we'll install upgraded door locks each unit. And again, the tenant amenities, we're going to be converting basically the existing reception building. That'll just be a resident clubhouse. So we'll add a pool table and put some chairs and make it kind of have that clubhouse feel for the residents.
No more buffet breakfast.
Correct, no more buffet breakfast. And it'll be a full upgrade of the fitness center in terms of the machinery.
But back to the fence, about the neighbor to is, well, we're going to continue to maintain that fence.
Correct.
Yes.
It does go all the way around, it actually goes along the main thing.
We would expect it to bring it up to repair up to a pleasant looking fence on your ownership or your.
Yeah, and as a good neighbor too, you can obviously, if there is a light that's disturbing. Sorry. Yeah. If there are any issues with the lighting, we're more than happy to address that. And we'll be more than happy to identify which light it is that's shedding light on her property and make the repairs that's needed.
Thank you.
I want to address the noise. So
Yes.
there will be rules and regulations that each tenant will sign off on, and there will be a noise ordinance. So not
I'd like to
noise
have
after
that in my
10 p.m.
neighborhood.
Right? Well, there is a noise ordinance. You just got to call the police.
Ultimately, the noise ordinance is with the city, so nothing to do with conflict. The problem with both police and the police deal with it.
Well, a lot of conflicts do that. Have their own rules. And, yeah, it's a convert kind of.
Yes, for the consideration of other neighbors.
Right, it's the same thing about leaving the carpet outside.
Right.
If they do that, you know,
Right.
that.
Yeah, you might want to
certainly
put
gonna
that
be-
in your
yeah,
rules.
yeah,
so not to be
yeah,
a violation.
Violation.
Yeah.
Yeah, you don't want the record. Using the pool.
Anything else, Attorney Thomas?
No, I think we've covered everything and like I said, and, you know, I recognize and we understand the situation of the adjacent property. And she's impacted by the two developments and she deserves to be appropriately buffered and continue to be buffered. Oh, this will be good.
Oh, did you mention any landscaping?
We're gonna keep the current landscaping company. The landscaping's been in good condition.
Yeah.
And
You
the mulch has been nice, the
any
plants.
additional ones on the property line? Shrubs?
There's actually, if you drive around it, there's
It's pretty
natural
buffered
buffers
out.
around the front. And remember the front of it, you have the retaining wall, which has the ivy that's going down over it. But when you go in, and I noticed it only because I had to stick my sign in the landscaping bed in the front, you know, my hearing sign, and it looked like it had recently been treated, weeded, and everything, and driving around, all of the bushes and everything seemed to have just been. So I must have gotten there a short time after one of the
Will there be any EV charging stations?
I think by state law, you have to.
I don't think that we addressed it, that's why.
Yeah, number one, I don't think. Reading the statute, you know, I'll start out by saying I don't think it applies because it applies to new construction, so this wouldn't be considered new construction. Yeah, however, that being said,
However, we have contacted vendors and we received quotes on that, and we'll award the contract after the zoning has been granted.
Okay. So you plan on putting in one or two or? Otherwise, you're gonna have people running extension cords
Yeah.
out there.
No, we talked about the possibility of 2 to 4, and the other thing is, you're basically putting in conduit, in certain
Right.
situations. So if you have to get more in, you would have to do that. And as we talked in previous applications, these people that are doing this are gonna have to address the issues with tenants who gets, access to the space and the type of, charges. Or we're seeing more situations where what do you call them? I call them the Tesla superchargers. Once those start
Fast
going,
charge.
yeah, once those start going in, I forget where I saw it, where basically you're in a residential property, you're allotted like an hour, because that's about all it takes to charge your car. So they don't want anybody going to it, plugging it in and leaving their car, those kind of situations. So you use it.
Do you have an idea?
Yeah, somewhere between 2 to 4, but
Okay.
it's going to depend on a lot of it's going to depend on the market,
Fine. As long-
but they're looking into it, even though it's only requires new construction.
All right, getting back to that. So you have a commitment for, you have 18, missing apartments, what about 19?
Well, 96 and 96 is.
Going by 10%.
Everything.
Okay.
40 years.
Yes, that's what it says in the statement of uses and standards, which would be changed from 18 to 19 units. Mine always referred to set aside units in accordance with 8-30G.
And certain times your client understands that based on the, because of the affordable housing units that we provided, and the interior renovations have to be such that as those affordable units become available, they are all have to be consistent. We don't have to micromanage someone and brand new others. So.
I know.
Should be at least 1 2-bedroom. Okay.
Well, that's the whole point. If somebody.
Well, because the mixture of it, they have many more
Right.
1-bedrooms than they do 2-bedrooms. So you can't say you got to split the 19 and 8 needs to be, because that.
And then once they become available, they usually, do that. I don't know, I don't support to be an expert on that division, but I forget where I saw it, I just saw something on a proposal, for affordable housing, and they actually designate the types of units. In other words, I've got to find what I was reading, there's something I was reading online, they actually designate, you're gonna have 3 studios, 3 one, but, yeah, it's actually.
Yeah, it's usually an equal mix. if
Yeah,
you will.
right. But, then the mix goes away once, these people go off,
You have the yearly.
Yeah, right,
That they, still, qualify for.
right, exactly.
Yeah, so if somebody comes in and you've got 18 of the 1-bedroom of the studios already designated as affordable, then you have to give up the 2-bedroom.
And if a person needs a 2-bedroom.
Right.
And that's why they have, that's how, have to.
If there's a 2-bedroom available.
Yeah.
Who is going to, what's the word I'm looking for?
Monitor.
Administrator.
Certified.
Yeah, who's going to
Yeah.
be doing this?
Great question. It's going to be Imagineers. They're an experienced property management group. They're based out of Hartford, Connecticut. So we're using them.
Okay, they'll be the management company in terms of collecting rent, et cetera, but are they also going to file the annual reports that they're in compliance with the?
Correct. Yes, they're experienced with the compliance portion of
Okay.
having
So the burden
affordable
will fall on the
units.
city.
Correct.
They will take-
They will take care of it.
And Shelton decided whether, let's talk about it.
I don't think we've come to a conclusion on that.
Yeah, I know that was.
That's why I'm asking the
Yeah,
question.
I know that was discussed, obviously, companies like this use the.
It would be preferential for all developers to do it on their own, but I understand some are very small, yours is rather large. or larger than some of the smaller ones, so.
Well, some of them are collecting fees from the various affordable units to supplement payment.
Payment.
Payment for, to have the professional company come in so that the town can have more control.
We just don't want the burden to fall on the city.
Oh, absolutely, I can take it. Yeah.
No,
Not at all.
All right,
Water
the,
before.
further, comments or concerns for the applicant? Okay, how about Commissioner Tinky?
No, those in the room asked questions I was going to ask.
Okay, so, how does the, commission like to proceed with this application?
Vote to close the public hearing.
All right, this, let's close the public hearing from Commissioner Apple, is there a second?
I'll second.
Commissioner Morrow has seconded, so on the motion to close, Commissioner Perkins? Aye. Commissioner Cristiano?
Aye.
Commissioner Amato?
Aye.
Commissioner Tinky?
Aye.
Alternate Commissioner Apple?
Aye.
Three votes aye, motion to close, passed by a vote of 6-0. How does the commission like to proceed on this application? Want some action tonight?
Think we should take action tonight.
I don't think we should get action tonight.
Reasons both of you.
Well, no, I think we should maybe move to a favorable resolution, but I think the resolution has to be a little bit more than just
A roll call.
vote. Yeah.
Given all.
I think there's a
Yeah,
lot of things we
yeah.
asked for that we
Yeah.
need to kind of
Put in
document.
writing,
So
yeah.
I think
Hold them
if
to
we
it.
just, if we're ready to move toward a favorable resolution, pass that and then, pass staff.
All right, then let me just poll the commission, because that's what we've done in the past to find out who will stand on this particular application, so, Commissioner Morrow, can I start with you?
Yeah, I would be in favor of what Ruth said about, moving toward the favorable resolution, but putting everything in writing that we've talked about. We want to make sure it's gonna be enforceable.
Favorable.
Yeah.
Okay, Commissioner Apple?
Yes, I do agree.
Okay, Commissioner Perkins?
Yes. I would vote for it.
Commissioner Cristiano?
I disagree. I think things we discussed are not changing, they're minor in nature, that can be laid out here tonight and get this resolved.
Okay, and so.
But,
But the whole
can I just
point
say,
is not when it's gonna be done, but are you looking for a favorable resolution or
Yes,
is unfavorable?
favorable.
That's all I'm asking right now.
We-
Okay, that's all I'm asking. And Commissioner Tippy? What's your,
Yeah, I would agree with a favorable resolution tonight, and then we vote at a future meeting.
well, not so much tonight, I need
We
a
vote on the
sense
resolution.
of whether or not people are leaning towards an eventual approval of this or not.
Yeah.
And it sounds like everybody is.
Right.
So, because of the, complexities of this particular, kind of application, we have not done anything to this extent before, where we haven't just.
The nature.
Yeah.
well, the other thing is down the line, you don't have anything in writing to hold them accountable to all the things we've discussed.
Right,
It would
and
be in
if
some
the
old
commission
minutes or-
changes and,
Yeah.
Right.
Absolutely.
The neighbor comes back in and says they're not doing what they said they're gonna do, and.
We don't have anything to stand on.
Right, we'll see that there's a vast majority for favorable resolution staff. is blocked.
I just want to point out one thing. There is, we've been extending, things out. There is a requirement financing entity that still gets this fee and an appeal approval by October, I don't know, October 2nd. So doing the resolution, if you were to put it on 10, let's say, for example, Alexander was very prompt at publication. Publication would be a couple days later and you would be in fine shape. If it goes to the other meetings, it's going to create an issue with the financing.
Well, we have to look at who we and prepare the resolution. No, the 10th is 2 weeks from today. So there's a possibility, but we may not be ready to 17.
Well, even if it's passed on the 17th, we'd still be within your
Yeah.
October 2nd. timeframe.
Meeting scheduled for that.
Not yet.
But, I don't see a reason why it couldn't be ready by the 10th, but they.
Right, and then we go into effect on.
The effective date is not the issue. Effective date doesn't affect the appeal. What affects the appeal is publication. So for example, it doesn't make any difference if it's effective date of September 26th, for example. That would have the effect on, if it's 17th and it's published on 19th.
It's usually, published for Friday or Monday after.
Right. You have to go 15 day expiration. So, I think to comply, that's one of the issues. Financing to comply with it, you're talking about. It would have to be,
17th would be October 2nd.
Yeah.
What's your drop dead?
That's October 2nd.
All right, all you can say is so noted.
Yeah, I appreciate the thoroughness of the review, but again, as Dominic mentioned, our financing, if the project is delayed, even by a week, that could put our financing at risk. We're ready to deploy capital today. And other than the repairs for the lighting, if there's any other major concern that you guys have, we can definitely address that, and we would like to resolve it as soon as we can. Again, we are trying to help out the community by taking the transient development and providing a well-maintained property that's going to support the Shelton community at the end of the day. So for those reasons, I respectfully urge the commission, if we can come to a solution tonight, we're willing to accommodate however we can.
I cannot, I think we've accommodated the urgency already by putting it for this meeting. Exactly, so we are going to move the best of our ability. It's the 10th and 17th of this.
And I'm always willing to ask that I have been in the past. To work with whoever, if anybody drafted a final resolution to site like this, they in it, noting the various things in the resolution and the references.
Figure out conflict of interest. You're representing the applicant, and you also to have input on what the resolution says.
If I,
That's gonna
it's
come
not a
from.
question of in the past, and it's done in other places too, where in the past, that Tony would call me up and say, I've got a draft. You can find out ahead of time if there are any issues with that. I mean, that was it, not.
Sometimes those things are just better left between you and.
Well, but it's also done in other situations.
You didn't hear that.
To avoid considerable conditions.
It's
We wouldn't be doing our due diligence and.
Right, no, I'm not, I'm saying the resolution is. The resolution is. That. Which, that's the appropriate thing to do. I told people very clearly,
We're not gonna.
the reason we want to
Panel
build it is
response.
because of Tony's resolution. I'm in favor of it. I'm just saying that we're having situations where in this town, other town, okay, was this the language we discussed? Was this the language we, that's the kind of stuff that is going back and forth. Yeah, and everything like that.
Attorney Thomas, I suggest your engineer submit and do final site development where he's moving that one parking space. So we have revised. Draft.
Updated.
And also address the
Second
recycling.
dumpster.
Yeah,
Right.
the recycling.
So we have it.
Was there anything else?
Lighting.
Well, the lighting, we may have to get the neighbor to, really address which
That's a phone
lighting
call.
is. Yeah, right,
I wanna walk around. Okay?
because even if we look at where the lighting is. And about this one,
You understand?
We have to look at it night.
yeah, and
All right, so, the consensus of the commission is for favorable resolution to be prepared. If that's what you'd like to put the wheels in motion for that. Okay, so, I think that's it, and seeing if there's no other item on the agenda, there's this, adjourned as of 8:42 p.m. Thank you, everyone. Good night.